We have a large audience today, so please can you ensure that your cameras are off and that your microphone is muted. And if we find that your microphone does flip on during the session, we may well mute you. So please don't be offended. It's just so that we can manage the session and manage it well. I'm really delighted to see so many people joining us today. My name is Amy Hurst. I'm the Principal Social Worker for Bournemouth, Christchurch and Poole BCP Council, Adult Social Care. And on behalf of the Pan, Dorset and Wiltshire Teaching Partnership, we're delighted to be inviting Ian Brownhill to join us this morning for this very important masterclass. I'm just going to walk you through a few housekeeping points. Hoping my technology is working. The screen doesn't want to change. Bear with me. There we go. So as I said, cameras off, and if you can mute your microphones, please. Our timings today are we're making a prompt start now at 10 o'clock, and we're due to finish at around 1 p.m. We do plan to take a short comfort break midway, and we'll make sure that that does happen so that we can all have a bit of a screen break and get refreshments. As I said, there is a large audience today, therefore it's not possible for us to cope with the hand setting for you to put your hand up for questions until we get to a specific question and answer session. What we'd rather do, if possible, if you can put any questions that you may have or any comments into the chat bar. We've got a team of people that will help to answer those, and any that we're unable to answer that are specific to your presenters, we will make sure there is an opportunity to do that. If we become overwhelmed by lots of questions and we can't get through them in the session, please be reassured that we will look to answering those after the session, and we will share the question and answers at a later date. As I've explained, this event is being recorded today for future playback. It will be posted to our Teaching Partnership website in the coming days or weeks once we've got it all tidied and sorted. And if I can ask anybody who makes any comments or shares any case discussions, if we can maintain confidentiality as we usually would in any discussion that takes place, please. So without further ado, it's my absolute delight to invite Ian Brownhill, who's joined us this morning. Ian works for, I'm going to get my words wrong now, 39 Essex Street. He works in the Court of Protection. He appears in applications for the Family Division and the High Court relating to inherent jurisdiction. Ian is extremely experienced in with respect to the High Court of Children's and Adults, and has a huge amount of experience of working with social workers and Court of Protection. So we're delighted that Ian's joining us today, and I will now hand over to you, Ian.
Thanks, Amy.
There we
go. Good morning,
everybody.
Hopefully now, by the magic of Microsoft Teams, we will switch from Amy to me almost seamlessly, in fact. And I hope now that you will be able to see the slides. I'm up, hurrah. And this morning is all about the magic of the Mental Capacity Act, but also accepting at the same time, as I do, that lots and lots of people who work in this sphere, be it children, young people, and indeed adults, that the Mental Capacity Act is still, as bits of law go, relatively new, and there are still things that people find difficult about it. So today, no matter if you are a beginner, if you're intermediate or you're advanced in respect to the Mental Capacity Act, my hope and my aim is to try and give you a little bit of information or a little bit of insight that might help you in respect of your practice in this area. And when I talk about magic, I will confess that there is nothing which I think is more magical than Hollywood. And today I'm going to bring a bit of that blockbuster sparkle to the Mental Capacity Act. And I hope by way of the use of 10 Hollywood films, and technically 11 Hollywood films, I am going to be able to improve your knowledge of the Mental Capacity Act. And the first Hollywood film I'm going to mention is that absolute late 90s, early noughties classic, 10 Things I Hate About You. And you may remember 10 Things I Hate About You if you are of a certain age, like me, and you have a certain taste in rubbish rom-coms. My wife utterly despairs when I make her watch these things. But here on the left, you see the 10 Things I Hate About You movie poster. And for those of you who will have seen the film, you will remember that it's about two daughters who are going to their high school prom, and it's based on Shakespeare's story, The Taming of the Shrew. Now, before I take you to Hollywood, I'm going to take you back to Shakespeare, and I'm going to take you back to The Taming of the Shrew, because The Taming of the Shrew is all about bits and pieces which we need to think about when we're talking about the Mental Capacity Act. Because The Taming of the Shrew is essentially about two women and their marriages, and about how their family doesn't want them to make autonomous decisions for themselves about who they marry. And likewise, in respect to The Taming of the Shrew, it's also all about risk, and the risk about damage that will be done to the family's reputation. Sadly, too, just like in The Taming of the Shrew, when we're dealing with the Mental Capacity Act, money is a big issue. And sadly, greed is a theme in both. So if any of you have had experience of working in safeguarding with people who lack capacity to make decisions as to their finances, what you'll recognize is that sometimes people are motivated by the money that they may be able to access for people who lack mental capacity. And then finally, what The Taming of the Shrew is about, remembering it's a comedy, of course, is about people's identity and hiding who they truly are. And one of the things that a lack of capacity can sometimes do is conceal who a person is. Because of whatever dysfunction is going on with the functioning of the mind or brain, whatever disorder they have, there is something that sometimes goes away about that person's identity, or it changes in some way. And so identity is one of the things from The Taming of the Shrew, which we'll be talking about today. And within The Taming of the Shrew itself, there is one of Shakespeare's, in my mind at least, one of the most wonderful lines, where he says, one of the characters says, "The poorest service is repaid with thanks." And I have to say, I'm now on probably year 8 or 9, maybe even 10 of Mental Capacity Act practice. I have to say that one of the things that often strikes me is that people are often grateful for some help, even if that help is not the best thing it can be. And sometimes there is a sort of culture of accepting that we will follow particular pathways, we will meet minimum standards, and that is all we need to do. But again, one of the things I'm hoping to do today is to get out of that mindset of the poorest service is repaid with thanks, and instead think about what the person themselves might have wanted if they were putting together their own care package, if they were making decisions for themselves, and really trying to focus on what P themselves would have wanted. Now, in the next 90 minutes or so, I am going to take you through the following: assessing capacity, the concept that mental capacity is time specific, what I've called the aspirations of the elderly, public protection and best interest decision making, relationships and mental capacity, what to do when somebody might harm P, young people and the Mental Capacity Act, drugs, alcohol and mental capacity, culture and belief in best interest decisions, and then finally I'm going to move to coercion, control and undue influence, which are essentially outside of the Mental Capacity Act. In doing all of this, there are opportunities for you to ask questions. So the best thing to do, and I have a very active, very helpful, very experienced team of people helping me today, is if you have questions, pop them in the chat box as we go along. I probably won't be able to answer them as I'm speaking, but please do ask those questions. and we will collate them all at the end and hopefully try and answer all of them. And just because we are talking about Hollywood today, I understand that the Mental Capacity Act has some big fans as well. I was asked yesterday by the top of the Mental Capacity Act fan club, the Wiltshire Dolls team, to give them a shout out this morning. So a big hello to all of the Wiltshire Dolls team, who I understand are in attendance. I have no doubt that you will be asking lots and lots of questions. I'm also really pleased that so many people have joined who perhaps are outside where the partnership normally reaches. And so it's really great to see so many social workers, social work students and allied professionals here today. So starting out with this film, I don't know if you all remember The Eternal Sunshine of the Spotless Mind, people who essentially have a relationship that goes bad, and then they have a medical procedure to take away the pain of that relationship. Full confession, not one of my favourite films, but it's perhaps a sort of good starting point when it comes to how we go about assessing mental capacity. And all of you will be familiar, and I don't want to take you through it, but all of you will be familiar with section 1, 2, and 3 of the Mental Capacity Act. That is your basic building block for whenever you are required to do an assessment of somebody's mental capacity to make a decision. The other piece of basic building block, which is sometimes missing, is a case, a High Court decision handed down by Mrs. Justice Ties 8 years ago now, which is sort of colloquially known as LBX in the Court of Protection. And what LBX does is it sets out core decisions and core relevant information in respect of how to assess capacity to make decisions as to residence, care, and contact. And quite often in the Court of Protection, it's residence, care, and contact with which we're dealing. So it is a helpful piece of case law which you can follow. It is something that you can easily find, and it will help show you what you should be considering when you're doing a capacity assessment and what you shouldn't be considering. Now, the first thing I want to talk about today, rather than the way in which the law is set out and what particular words mean, is I want to talk about a process. And the reason I want to talk about a process is because one of the difficulties we find in the Court of Protection is that when it comes to conflicts about capacity, a lot of the time it's because people aren't following a natural process to underpin their reasoning. Now, the first of these issues along the way this morning is this first arrow here, the fact that a decision needs to be made. What we don't do is we don't assess people's capacity just for the sake of it. Now, you might say, Ian, well, as if we've got time to do that anyway, we are very busy people. I understand why you say that. But sometimes what we find is that there are examples whereby people will go and conduct generic capacity assessments in residence, care, contact, just because. So just because somebody is in a care home, just because somebody is having issues or having difficulties in respect of how they're getting along at home, just because there is a safeguarding concern. So we don't assess capacity just because. Instead, we assess capacity because we have a reason to believe that a person is unable to make a decision for themselves. Now, the core word throughout all of this, the core thing to take away is the concept of a decision. So the most basic fundamental thing is you have to identify what is the decision which is being made. And in doing so, you have to apply basic principles. The basic principles are that that capacity is issue specific, that capacity is based in the here and now, or potentially retrospectively, but most of the time is time specific, so a particular moment. And also that we're only assessing capacity for a person if it's a decision that P themselves could have made. P themselves can only decide particular things. So P themselves can't necessarily decide to go and live in the Ritz. P themselves can't decide to perform an illegal act. Okay. So once we've identified the decision, once we've identified that there is a reason to believe that the person may lack capacity, we then go on to the functional aspect and we think, is there some reason why the person is unable to make that decision? Do they understand the relevant information? Are they able to retain it? Are they able to use or weigh it? And finally, are they able to communicate a decision by any means? Now, if there is a dysfunction there, if there is some inability that is being shown, then we remind ourselves of section 1 of the Act and also other parts of section 2 and 3, and we try and do whatever it is we're able to allow that person to overcome that functional deficit. So we give them photographs of different care homes. We use Makaton. We show them pictures of people. We put people through education as to sex. If those efforts fail and there is still an inability, a functional inability to make a particular decision, we then move on to the last stage, the diagnostic aspect, and we say, is that inability because of an impairment of or disturbance in the functioning of the mind or brain? And if it is that we do not have a connection between the diagnostic aspect and the functional aspect, what we call causal nexus, then we can't prove a lack of capacity. You will appreciate that writing on this is not easy. So causal nexus is really important. So basically, is the inability to make the decision caused by the functioning of the mind or brain? Or if you're a beginner, even more simple than that, is it something internal about the person that is causing them not being able to make the decision? If it's internal in the functioning of their mind or brain, then it's a lack of capacity. If it's external, so some external feature, for example, somebody's threatening them, then it's not a lack of capacity and we're in a different jurisdiction. But we'll talk about that right towards the end of the presentation. So what are the bloopers? One of the things that will make me go absolutely James Cameron is if I read in an assessment, P lacks capacity, full stop. And if any of you out there are psychiatrists, then I have to say that your profession is absolutely the worst at this. So psychiatrists produce documents all the time that simply says P lacks capacity, full stop. And we know that that is wrong, okay? We know we don't put that in any of our written material. We know that we don't put that in any of our assessments. If we are going to submit, if we're going to say that P lacks capacity to make a particular decision, then we identify what the decision is. P lacks capacity to make decisions as to their residence. P lacks capacity to consent to sexual relations. P lacks capacity to purchase a house. All right. The next aspect, which is sort of increasingly becoming problematic, is the concept of insight. So insight, or having sort of self-awareness of one's own limitations, is a clinical construct that quite often is used with people who've got psychiatric issues. And we talk about them having insight into their own particular difficulties caused by their illness. The concept of insight has been sort of imported through the back door into the Court of Protection by way of the Mental Capacity Act, but also into sort of everyday practice of social workers. So P lacks capacity because they lack insight into. The word insight doesn't appear anywhere within sections 1, 2, or 3 of the Mental Capacity Act, but instead it's essentially being used as a means of showing that a person doesn't understand the relevant information. So it may, more often than not, appears in cases where you're dealing with whether or not somebody has the mental capacity to make decisions as to their care and support needs. And what often we quite see included is that it's said that someone lacks capacity because they lack insight into their care needs. The law doesn't say they need insight into their care needs. What the law actually says is they have to understand, retain, use, or weigh those care needs, but also what happens whether or not that care is taken away. So the sort of concept of insight has been used almost to overlay other people's assessments. So, for example, you go out, you conduct a Care Act assessment, and you say, these are the Care Act domains where somebody has care and support needs. You then do the capacity assessment, and you say, these are your care and support needs, I've assessed them. And then if somebody doesn't engage with those care and support needs, or they downplay them, you say they lack insight and therefore they lack capacity. And what I'm saying is you need to be really, really careful with that, because firstly, the word insight doesn't appear within the Act. But secondly, you have to be very clear whether or not it's a person lacking understanding or the ability to retain or use and weigh, or it's somebody simply disagreeing with a professional assessment. And again, that's an area where we see increasing levels of confusion and conflict and cases being born out of it. The other thing we see, sadly, now is that there is a tendency to overload what the relevant information is in a particular case. So the relevant information is essentially what P has to be able to understand, use, or weigh and retain. That's in order to make a decision. That's not, emphasize not, a requirement for them to be able to understand, use, or weigh and retain long amounts of case history about themselves, or indeed large amounts of information in respect of how assessments have taken place. There are documents setting out guide relevant information in respect of a number of the core decisions that you'll be asked to assess in respect of mental capacity. And there are some links to it later within the slides. But essentially, the High Court, Court of Protection, has on a number of occasions said, this is relevant to a particular decision, this is not relevant to a particular decision. And those authorities are really helpful, but also really important if you want a capacity assessment to stand up in court. The other thing that is the sort of perennial source of angst is the concept of abstract assessments. So we are now 9 years on from the decision of the Court of Protection in CCKK and STCC, which said loud and clear that we don't assess capacity with a blank canvas. Instead, what we do is we put to people concrete options and we say, this is, if you're doing, for example, a hospital discharge case, you say, these are the two options which are available. You go to your own home, or you go to the Cherry Tree Care Home. This is what the Cherry Tree Care Home looks like. This is what your home looks like. This is what care is available at Cherry Tree. This is what care is available at your home. We don't abstractly talk about the concepts of residential care, nursing care, EMI, whatever. We give people instead the sort of solid options which are available. And the court's been very clear about that, and has been quite critical when abstract assessments have been done. So how I would encourage you to improve your practice in this regard. So if you're somebody who is starting out in your practice, if you're a social work student, or you're a social worker who's only just doing mental capacity work, a basic, really helpful starting point is to start every capacity assessment with a list of what you consider the relevant information to be. That's different from starting a capacity assessment with the background of a case. So there's a tendency at the moment to do to draft a background of a case and then go into your assessment. Whereas actually it's much neater, much punchier, and much clearer for a judge potentially if you start your capacity assessment with X, Y, and Z is the relevant information. If you think something in particular is irrelevant, you can also say at that point it's irrelevant. Those of you who have been in practice for some time now probably are already doing somewhere in your assessments what you consider the relevant information to be. What you don't necessarily do, although some of you are very good at doing it, is say, well, in coming up with this list of relevant information, I looked at the following cases which set out a guide to what the relevant information is. So, for example, I gave you the example of LBX earlier to deal with residence, care, and contact. You've got the case of B versus the local authority for internet and social media. You've got the case of JB in a local authority for consent or engage in sexual relations. You've got REH for marriage, and so on and so forth. You've got lots and lots of different REGP for cases in respect of capacity to make decisions as to education. And linked here, underlined, is a document put together by 39 Essex, where we have effectively given you a single PDF which cross-references lots of the different cases and tells you what the court has held the relevant information to be. So either click on the link or go on the 39 Essex website, and what you'll find is that there is a long document which sets out relevant information and where we've got it from. Finally, if you are someone who is long in the tooth in this, and you consider yourself a mental capacity assessment master, as many of you are, no doubt, one of the things that I really am keen to encourage and keen to start a fashion, a trend, a craze for, if at all possible, are multidisciplinary assessments of capacity. The reason why I think multidisciplinary assessments of capacity work is because I love the idea of social workers who have got a command of how the mental capacity legislation works. Assessing capacity with people who know P really well, so for example, care home managers, care staff, nursing staff, and so on, who may also work together with someone like a speech and language therapist in order for communication to be improved, or might work again with somebody else, for example, a psychologist or a psychiatrist, to look at how the causal nexus works or the diagnosis works in a particular case. Those multidisciplinary assessments in complex cases would save time and would save money in the long run. So it seems really difficult to persuade everyone to get together to do this piece of work. But if you compare that to there having to be 2 or 3 court hearings and then potentially an independent expert or more than one independent expert in a court case, you're actually saving money and time in the long run, which can only be better for P, I think. So the next issue I'm dealing with by the magic of the film Memento is that mental capacity is time specific. I have to say, and I know that many of you will become very exasperated by this, and if you're a film buff, certainly more than me, and you have better taste than me, you will say that Memento is an absolute classic. I absolutely cannot stand the film, but the film is about a man who's got memory loss, who tries to work out who killed his wife. And it's just, I don't think it's very good. But there we are. You're not here to hear about why I rate things as I do on IMDb. You're here to learn about time-specific mental capacity. And again, time-specific mental capacity is something which is a freestanding problem. It's a freestanding reason why people don't like the Mental Capacity Act, because it causes loads of headaches. So we start off really with the concept of retention. Not only retention, though, but the concept of materiality. So I talked earlier about how we identified what the decision was and then the relevant information that goes along with the decision. So that bit is just simply a decision, okay? It's covered off there. The difficulty that people have is this concept here, material time. Now, material time, quite literally, means the point at which the decision has to be made or has already been made. So if you are a safeguarding social worker, you may be asked to do a retrospective capacity assessment where the material time is not right now, but is looking back into history. That means that you might, for example, be looking back 2 years to determine whether or not, in your opinion, on Y date, somebody had the capacity to make a lasting power of attorney. That is quite advanced assessment. It's quite difficult, especially because you have to understand the progression of diseases and you have to use collateral evidence. Most of the time, what we're doing is actually capacity assessments at the point where a decision is being made, or if, for example, you're a hospital social worker, you may be asked to do a capacity assessment which has prospective impact. For example, you may be asked to assess whether or not somebody would have capacity in 2 weeks' time to have their teeth removed, or you may be asked if somebody would have capacity in 2 weeks' time to be discharged to a particular place. And now all of that is complicated. I fully accept that. But the easy part, which people miss, is identifying firstly what the material time is. So if you are that hospital social worker who is determining whether or not somebody has capacity to make decisions to where they're discharged from hospital, the material time is the point of discharge. You may be doing it slightly further in advance than that. I imagine you probably would, but that is the material time. Likewise, the material time can be retrospective, as I've explained, or you could be looking in the future in time. What material time causes problems with sometimes is the concept of retention within the Mental Capacity Act. So retention is not a memory test, okay? Those of you who've done training with me before will know that I will absolutely go nuclear if I hear people who are said to lack capacity because, for example, it is said that they don't know who the Prime Minister of the United Kingdom is, or they don't know who the President of the United States is. completely irrelevant. Likewise, it's equally irrelevant if somebody can't remember what their childhood home was or their previous address was. It's irrelevant. In terms of retention, what is required by the Act is that the person is able to retain the information as set out in section 3.3 for the amount of time necessary to make a decision. So if a person, for example, has delirium, they're going up and down all the time, but they come out of a period of delirium and the doctor turns to them and they say, look, this is what's about to happen to you. I'm about to take you into theatre and you're going to have X, Y, and Z procedure done. This is the information. Do you consent to the procedure? Do you understand this, etc.? If that person retains for that amount of time the relevant information in respect to that particular medical intervention, they sign the consent form, they say, yes, thank you, doctor, off they go. And then their delirium comes back and they can't retain anything, then they've still made a capacitous decision, okay? Because at the material time, just as they were about to go into theatre or whatever, they made a decision. They were able to retain it for a short time. They then lost capacity again. We fully appreciate that as they were being wheeled down to the operating theatre. That person still has made a capacitous decision because at the material time they could understand, retain, use or weigh the relevant information. So what we do wrong in all of this is we sometimes don't say, in respect to the person who's got the up and down delirium or similar, we don't say, well, actually, we'll wait and see if that person improves. So if you've got someone who's going through alcohol withdrawal and all of a sudden that person is very unwell, you don't assess their capacity at the point they're very unwell unless you absolutely have to. Rather, instead, you wait and you see what happens later. You wait, if you possibly can, and assess their capacity after a few days to see if they've improved and that functionality has improved. There's also what goes on when there may be a challenge later to the decision that a person lacked capacity or whether they had capacity. Now, one of the strange phenomenon that we've been sort of experiencing in the COP over recent years is that we have said to us, on X or Y date, so-and-so had capacity. And more often than not, this comes up in two contexts, certainly in my experience. The first context doesn't really probably apply to many of you, but just to tell you, the first context it applies to is medical stuff. We get clinicians who say to us, oh, so-and-so had capacity to consent to that. There's nothing recorded about it in the notes, but they had capacity. They had capacity to make decisions whether it was being discharged to. So we get that a lot. The other thing that we get it a lot with is where people are said to have capacity when they're being removed from their homes. And we get, oh, so-and-so had capacity at the material time. They consented to being removed from their home and moved to a care home. And then in both of these situations, when we try and scratch under the surface, because we have suspicions or that they lacked capacity, or indeed they lack capacity now, we get told, oh, well, presumption of capacity, there's nothing you can do about it. But that's a massive blooper and it's a massive misunderstanding. So I don't want to encourage you all into defensive practice, but in terms of justifying and explaining, if you have somebody whose capacity is questionable and you are treating them as making a capacitous decision, that capacitous decision needs to be properly recorded. It needs to be there in the form of an assessment. You can't simply rely on the presumption of capacity as a shield, sort of looking back in history, because people will question you. People will question the legality of stuff. And we've had it in cases which are really obvious. So people who've been born with lifelong disabilities, we've had it where actually people are saying, oh, well, you know, we didn't do a capacity assessment at the time, but presumption of capacity. And it's really easy to rebut. We go, well, hang on, that person's never had capacity. They're never likely to get capacity. So it's something to really focus on and think about. I'm not encouraging you to act defensively, but it's something which you should think about, because if you have got someone who's gone from a state of being capacitous to losing capacity to make a certain decision, one of the things that we might do is try and work out what caused that lack of capacity and whether or not we can return them to capacity in future. So it's not just about being defensive. It's also being about being facilitative in terms of helping someone potentially return to capacity. So really difficult stuff is in respect of how you assess somebody's capacity in respect to the material time when it comes to deprivation of liberty. And if you're starting out in this, and before LPS kicks in and we have the LPS guidance, if you're a beginner, I think a really good starting point is to look at the Dole's Code of Practice and to look about how that deals with and characterizes the material time. The next one to deal with, if you're someone who is further down the road in respect to your practice and you're sort of on the intermediate level, is the decision of the Royal Borough of Greenwich and CDM. That case is all about diabetes management and about the concept of macro decisions and micro decisions. So it's about fluctuating capacity as a result of the impact of someone not taking their insulin and the impact that has on someone's decision-making processes. And that case talks about someone might have individual capacity to make lots and lots of micro decisions, but on a macro level, they're not able to make an entire decision for themselves, because when you add up effectively the whole process, they're not able to make a decision as to how to manage their overall treatment. And in that's the case all about diabetes. But it's really helpful. So if you've got a case where you've got someone in the community who has fluctuating capacity, it might not be diabetes is obviously one, but say, for example, you've got somebody who has good days and bad days, or who will take their pills on certain days and not take their pills on other days, then CDM, macro and micro decisions should be really helpful to you, I think. The next one I just wanted to talk about, if you are somebody who is confident with the Mental Capacity Act, is conducting retrospective assessments. Retrospective assessments are actually really important things. They're really important if you are anybody who is in safeguarding. So if you are in a safeguarding team and you're dealing with stuff like financial abuse, you're dealing with decisions that have been made on particular dates as to whether or not, you know, if somebody had a child or a family member or an acquaintance move in, then retrospective capacity assessments are really important. So a retrospective capacity assessment is something not to be undertaken by a beginner, but essentially what it means is that you, as a sort of advanced practitioner, look at look at their capacity now, look at evidence as to what their capacity was at a particular time, and you extrapolate, assess whether that person had capacity to allow their daughter to move in, whether they had capacity to grant a lasting power of attorney to their neighbour, and so on and so forth. It's advanced practice, but it's really important stuff. And I would encourage you, especially if you are in a safeguarding role, to see whether or not you feel confident doing that type of assessment. So the next film is an absolute favourite of mine, not least because it is Pixar, but also it has a really cute dog in it, which I really love. So you'll all remember Up. So Up is about a 70-year-old man, lives alone, ties a load of balloons to his house Boy Scouts trying to sell him cookies, and they all go off on an adventure together. It's all about elderly people. It's all about elderly people having dreams. It's all about risk. It is a film about the Mental Capacity Act, if there ever was one. I absolutely adore it. It's a great film. If you haven't seen it, watch it. If you've got children or you've got elderly people in your family, then make them watch it too. It's great. In fact, I think it should be on the syllabus for all social workers who work with elderly people. So the aspirations of the elderly is perennial problem. It is perhaps something that is one of the greatest battlegrounds, if you like, in the Mental Capacity Act and the Call to Protection. It is about ultimately autonomy versus risk, and that's why I've put in there the authority about MM and adults, an older authority, but one worth a read. And it's about this sort of difficulty that quite often older people don't want to receive care. They don't want to leave their own homes. They want to do other things. Family members, professionals think those other things are too risky. And it's about balance. And I say from the outset, I am not somebody who believes that autonomy is limitless. There are cases where I fully agree and I fully accept that the state has to step in. Indeed, if someone in your caseload does attach a load of helium balloons to their house and attempt to kidnap a local Boy Scout, that probably is one of the limits. So I fully accept that autonomy is limited. I also, from a purely pragmatic and practical perspective, understand that local authorities do not have the funding to put in place care packages or commission placements that are perfect. I get that entirely, and I preface everything I say with that. But I do want today just to try and encourage you to think more about how we deal with the aspirations, and that's why I've called it that, the aspirations of the elderly. So the first thing to say is a really basic point, but let's face it, in Section 4 of the Mental Capacity Act, the word risk does not appear. Section 4 of the Mental Capacity Act about making best interest for decisions for a person who lacks capacity, at no stage says this is a risk assessment, this is a risk balancing process. It never says that at all. Instead, we've got the best interest checklist. And so that is a sort of basic axiom that has to be carried through whenever you are doing a best interest analysis. It doesn't matter if it's from what a person wears, what the person has to breakfast, all the way through to life-sustaining treatment. We are doing the same thing whenever we're making a best interest decision. Likewise, in respect of Article 5 of the Convention, as well as there being a sort of negative obligation not to lock people up without lawful authority, there is a positive obligation too placed upon public bodies to try and identify an alternative that doesn't require a person to be deprived of their liberty. So that is essentially looking for options which are less restrictive than the option currently imposed on a person, so that it amounts to a deprivation of their liberty. Now, all of this, as I said earlier, is predicated on the idea that we are involved in a balance. So what we don't do is we don't say person has had accident in their own home, therefore it follows that that person should automatically be moved to a residential care setting. The bit in the middle is the Section 4 analysis, which looks at the benefits and the burdens of somebody remaining in their own home. It looks at the benefits and the burdens of receiving a care package which is not 24 hours a day, or which might be provided in part by family members rather than professional carers. So all of that is important. And one of the things that is quite disheartening, although I have to say doesn't feature so much on the South Coast, but it does feature in other parts of the country, is hospital discharges, failed care packages, where the instant response is to move the person into the first available care home. And that's really sad. And I appreciate that is partially due to the pandemic. I appreciate that's partially due to budget constraints. But it's certainly not the way that anybody intended it to be. And I have absolutely no doubt that when all of you signed up to be social workers, allied professionals, working in the care sector, wherever you do, care home managers, I'm sure that's not what you wanted to do, or why you wanted to do it. And really, this sort of comes to my first blooper. And my first blooper is elderly people sitting on loads of money. It drives me mad. So people save up all their life so that they have got some form of nest egg in their old age. It is, tale as old as time. It features in literature. It features in film. You have the person that you have their nest egg. That person doesn't necessarily know, or in some cases, doesn't necessarily have the capacity to use that nest egg in order to facilitate them having a better life, or potentially sustaining a package of care in their own home. And so one of the frustrations is that we have people moved into care homes because of perceived risk. And then we have court of protection proceedings when they object to being in the care home. And we suddenly find out that person's got £200,000-300,000 in the bank. And they can sustain a package of care at home, which is more than what they had before. So we then move them out of the care home back into their own home. So that's a source of frustration. The converse to that are those family members who say, whoa, I don't want this person having this really expensive package of care, or these really expensive adaptations to the home, because that would diminish my inheritance. And I don't want that. No, they should go into a care home. It's much better for them. Those people have an absolute misunderstanding of how inheritance works. So inheritance, you inherit money because it's left over, because it wasn't needed anymore by the dead person. So this concept of a loss of someone's inheritance, or what's owing to them, really winds me up. And it does sometimes feature in Section 4 analyses. You can almost, some people will actually come out and say it. Will say, oh, mum wouldn't want to spend her money that way. Other people, it's much more subtle and insipid. But I would say, as social work professionals, that you are in a great place to challenge that and to be creative and say, well, if we put this in place, we can meet your mum or dad's aspirations. They can stay in their house, and so on and so forth. And the other case which I love, and if you haven't read this case, it doesn't matter what level you're at the Court of Protection or in mental capacity, you should read it. The next case is about Peggy Ross and her cruise. So if you haven't read it, Peggy Ross was a woman in her 80s, had various care needs. I can't remember what now. And she basically just wanted to go on cruise and have a great time. And the local authority were like, whoa, no way, that's way too risky. We don't want Peggy going off on her cruise. And they put in place a standard authorization to deprive her of her liberty, I think in a care home. And the matter ended up not only in the Court of Protection, but also ended up on the national news because Peggy had been wrapped in cotton wool. And in that case, Peggy was allowed to go on her cruise. She didn't fall overboard and it wasn't all catastrophic. But it's just a really interesting case from the perspective of how risk was seen as being everything. Peggy's happiness sort of took a back seat. But it's also really interesting from the perspective of, as a law geek, sort of procedural impropriety. So rather than take the issue, identify the decision, does Peggy have capacity to go on the cruise? Rather than make that decision and take it to the court of protection because there's a dispute, instead it was slap a doll on her, slap a standard authorization on her, keep her where she was. And so the court was very critical of that too. So again, thinking about how we not only approach aspirations and we approach risk management, but asking why we're asking for standard authorizations rather than identifying a particular decision and potentially taking it through to the COP if we have to. Again, really important. So how you're going to improve your practice. And for the beginners amongst you, I am going to send you off to one of my favourite cases, and that is the decision in Mrs. P versus Rochdale Borough Council. And Mrs. P versus Rochdale Borough Council is all about an elderly lady and her dog, Bobby. But it talks about the Court of Protection's approach to P and their pets and taking them into care homes. You will also see an almost pantomime villain in the piece, who is the deputy, who was heavily criticised by the court for suggesting that you can't possibly take dogs into care homes. It's far too risky. And I will say again, whilst I've got you all here, that I have a case on the South Coast quite recently where we managed to place a dog called Bobby the dog. Not called Bobby the dog, that's the name of Mrs. Rochdale. I've now forgot it. Bugs the dog, that was it. We recently placed a dog called Bugs in a care home. We were heroes to all in respect of that. So it's all possible. It's all possible to do. If you are someone who is intermediate and finding your way around the Mental Capacity Act and the Court of Protection, I just want to ask that you consider the case of Sikora and the Czech Republic. This is a European Court of Human Rights case, which essentially it's almost like a litany of woe. So it's everything that can go wrong in a case about someone who lacks capacity. And the European Court of Human Rights sets out on every possible level what went wrong at each stage, how P wasn't afforded representation, and so on and so forth. And it's just a really interesting case if you are sort of learning more still and you want to learn about the next level, but you want to learn about sort of procedural fairness as well as the sort of substance of how the Mental Capacity Act works. Then if you're an advanced practitioner, I would really encourage you, especially if you're a manager, to consider how your team deals with urgent removal cases and whether, firstly, you've got a process in place, but secondly, whether that process is lawful. Again, we are beyond where we were with this, but we still see cases where people are essentially unlawfully removed from their own homes and placed places. I had a colleague phone me the other day about a case where the local authority managed to persuade the police to bundle P into a police car and remove them to a care home. Needless to say, that case is not going well for that particular local authority. But, do you think about it? I also think it's possible, although I haven't quite worked out how yet, I do think it's possible to work out a toolkit or a sort of flowchart or something which you could put in place for urgent removal cases, especially if you worked with your legal departments. And I will take this sort of particular moment just to remind you all that 24 hours a day, 365 days a year, there are Court of Protection judges available. And I can fully attest to that, considering that at 2 o'clock in the morning on Christmas Day last year, I was awake sorting out an urgent removal of a man with terminal cancer from his own home. So Yes, there are judges there. It is possible. There doesn't have to be a delay in bringing a case to the COP. Now, the next film is Joaquin Phoenix in The Joker. And if you haven't seen that film, then I command you, if I have the lawful authority anyway, I command you to go and watch The Joker. It is a fantastic film. If you've seen Batman and so on, you'll know who I'm talking about. And it's all about a man, a comedian, who essentially feels wronged by the world and descends as his mental health gets worse until he becomes the Joker, this sort of Machiavellian evil monstrosity of criminality. And public protection and best interest decision making in the Court of Protection and the Mental Capacity Act is a really fascinating area, because again, Section 4 of the Mental Capacity Act doesn't talk about public protection. It's not like the Mental Health Act. There is no mention of public protection within the Mental Capacity Act. There is no mention of it in Schedule A1. And indeed, when LPS, the Mental Capacity Amendment Act, was going through the Commons and the Lords, one of the debates, especially in the Lords, was about whether or not public protection should become part of the DOLS process or the LPS process. And the answer was a resounding no. So the court has, over the years, taken it upon itself to write its own script with regard to public protection and best interest decision making, which arise from a decision of a judge, Mr. Justice Moore, in the case of Y County Council and ZZ. It's not one of my favourite judgments. I'm very critical about it, as much as a barrister can be critical of a High Court judge. But that's how public protection and best interest decision making basically got started. It's always been there in the background, but that case is the one that people go to when these situations arise. So in Y County Council and ZZ, there was a man who was essentially a predatory paedophile who had had previous detention under the Mental Health Act, had come out of hospital on a guardianship, and then was doled. He was doled because he was at risk of approaching small children and becoming aroused. And the problem was, when he went up to those small children and became aroused, the family members of the children would beat him up, assault him, and there was a concern that he would, of course, end up in the forensic mental health system or the criminal justice system. So Mr. Justice Moore comes along, and the official solicitor on behalf of ZZ agrees that restrictions can be imposed in this way, although I don't think there was much thought about the potential for what would happen next. And so the judgment says, essentially, you can, when making a best interest decision, although you can't consider the protection of the public, the judgment talks about considering keeping other people safe. It talks about keeping P out of the justice system. It talks about keeping P safe from retribution, but also keeping P out of mischief. So keeping P out of mischief and keeping others safe has no statutory basis whatsoever. There is an argument to say that there is, in your best interest decision making, you can factor in that P would be at risk of retribution if they commit offences. Keeping P out of the criminal justice system, I think, is an incredibly, incredibly difficult issue, because I actually think that some people who lack capacity may be better off in the criminal justice system than they are going through the Court of Protection, Mental Capacity Act, and so on, simply from the perspective that they are better protected procedurally. So the criminal law has certain protections for a person accused of a crime before they can be punished or have restrictions put on their life. The Mental Capacity Act and the Court of Protection have less procedural rigour in that respect. So and I also have heard forensic psychiatrists in particular, and forensic social workers, say to me they wonder too whether keeping P out of the criminal justice system is a good thing, because it means that P actually doesn't learn from anything. So P has no boundaries because they know that the police won't arrest them. So it's a really, it's potentially a really difficult issue, it has to be said. The bloopers in it are multifactorial. One of the ones which we see more and more is that what tends to happen if you have P who is a high risk of offending, and more often than not, being frank with you, it is high risk of sexual offending, local authority will find themselves, quite understandably and quite properly, drawn into risk management type arrangements for that person. And that's usually by the way of MAPA or something like that. And at those meetings, there are decisions made about P which almost take on a mythical value, where they're almost treated like best interest decisions. But they can't be best interest decisions because Section 4 isn't being applied and P is not represented in the process. So instead, you have this MDT decision, which is heavily led by the police probation service, where essentially pressure is applied to the social work and the health colleagues to put in place restrictions with a public protection view. And it's very difficult for people who work in social care or work in healthcare to say no to the police and the probation service in that regard. But say no, they must. That is, you can't make best interest decisions under the Mental Capacity Act and use the Mental Capacity Act to stop someone committing offences through a forum like MAPA. It just doesn't work. And we had a case. I had a case in over the border in Wales where that was that was really apparent, and there was real pressure on the social workers in the case to do that. But the local authority and the health board in that case stood firm with us and pushed back, and in the end, it's all worked out very well for P. But that is something to be certainly something to be thought about and considered, especially if you have P who is at risk of committing offences. The next area is more in circumstances in respect of contact. And I'm sort of loath slightly to raise this because again it's very complicated, but it's worth talking about. So incapacity to make decisions as to contact with others, so the sort of generic capacity assessments. One of the things which Mrs. Justice Ties said in LBX was you have to have capacity, you have to be able to understand, retain, use or weigh the advantages and disadvantages of having contact with a particular person. And so that feature is pretty well established when it comes to assessing capacity to have contact with others. It does cause a slight problem in forensic cases, and I call it forensic cases, where P is said to pose a risk themselves or P has been convicted of offences. And what we're seeing are capacity assessments which come back and say that P lacks capacity to make decisions as to contact with others because P doesn't understand the risk that they pose to other people. And that's really, really difficult for you to take that line. It's really difficult, firstly, because very few of you will have the sufficiency of expertise or the experience to actually risk assess what P's risk to others actually is. That's a sort of basic starting point. The second is there is a question as to whether or not P has to recognise their own risk factors, the risk they pose to other people, or whether it is simply that P has to be able to recognise the risk that others pose to them. And really that goes back to first principles. Do you, as a person, when you are making decisions as to whom you want to see, do you make decisions based on what your impact is going to be on that person, or do you make those decisions based on the impact that person is going to have on you? So it's a difficult one. It's not necessarily something to rely upon, I would say. I think there are better ways of dealing with it, quite often, to be honest, through care and support. So putting together care packages around people that potentially helps them to ameliorate their own risk. A shameless plug. If you're a beginner, I have done a very basic starting point called Myths and Mistakes of Capacity and Criminality, which is available on the Court of Protection Open Justice website. Have a read of that. It talks about P as an offender. It talks about P as a victim of criminal offences. Also talks about what to do when P is a prisoner and has mental capacity issues. If you are an intermediate practitioner, I'm going to send you all off to go and read London Borough of Enfield and SA. That talks about when P is a victim of criminal offending and is a stark reminder that the police cannot just go and interview people, seize their goods, so on and so forth, because they've been a victim of crime and they lack capacity. So have a read of that if you've got, especially perhaps if you're dealing with, again, safeguarding or a vulnerable client group who people pose a risk towards, so they're victims of offending. Then, if you're an advanced practitioner, I am going to invite you to do this. Ask yourself, what are your team's arrangements for when somebody comes out of prison with mental capacity issues? So you probably know, if you're an advanced practitioner, what happens when somebody is coming out of mental health detention. You probably know how that practice works, and you probably know how to get deprivation of liberty sorted out and authorised in advance, and so on and so forth. What we do see a lack of is the same being applied to prisoners, unfortunately. And so prisoners quite often find that they have disabilities, they come out and those disabilities aren't met. Another shameless plug about that point, can I just make it now? Alex Rutkeen, Francesca Gardner, and I are all doing a free seminar similar to this online later in the year, where we are producing a specific piece of guidance, again, which is going to be available free to all of you, about prisoners who lack capacity to make certain decisions. So if you're not signed up to the 39 Essex website, do sign up, because that's later in the year. And it's important if you've got a client group who's coming out of prison potentially, or indeed potentially going into prison as well. So I now move on to one of my favourite films. I'm not going to say life is like a box of chocolates. I'm not going to say Bubba and talk about the shrimp or anything like that. But you would all no doubt have seen Tom Hanks as Forrest Gump, which is all essentially at the heart of it about a man and his relationship with a woman. He is a man who has an IQ of 75, and it's all about his relationship with her. And my wife does a very bad impression of Forrest Gump, which I won't share with all of you. But needless to say, it amuses me greatly, but it amuses our baby more when she does it. It is a fantastic piece of film. It's a fantastic piece of film because it has a person who has a form of cognitive difficulty, has a learning disability in it, who lives a life which is full of action, adventure, and indeed love. So I love it from that perspective. And again, if you're a student social worker and so you don't know what I'm talking about when I talk about Forrest Gump, I command you to go onto Amazon, IMDb, Netflix, whatever it's on, and to watch it later today. So the Mental Capacity Act, again, in relationships is sort of a bit rubbish. Thus, 10 Things I Hate About You. So Section 27 of the Mental Capacity Act excludes the Court of Protection, or indeed yourselves, from making best interest decisions for people to consent to sex. So the court of protection, or indeed a social worker, cannot consent to sex on somebody else's behalf. It's an excluded decision under section 27. What is the decision about consent to sex is something which is incredibly controversial, and is currently sort of stuck in a bit of legal limbo. So the current leading authority on consent to sexual relations is the judgment of Lord Justice Baker in a local authority and JB. So that Court of Appeal decision came out last year. I then appealed, along with others, that decision on behalf of Mr. JB. And so next month, on the 15th of July, the Supreme Court will be determining how we approach questions to consent to sexual relations and the Mental Capacity Act. And here, for those of you who are so inclined and so excited, are the decisions or the questions that the Supreme Court will be answering. So the Supreme Court will effectively answer, we hope, finally, what is the relevant decision to be assessed? Is it, does P have capacity to consent to sexual relations? Is it, does P have capacity to engage in sexual relations? Or both? So is there a difference between a P who consents to sexual relations or a P who engages in sexual relations? Spoiler alert, I say that it can only be one or the other. It can't be both. The next point is, once we've identified what the relevant decision is, what is the relevant information? And in particular, in JB's case, the argument was around whether and to what extent P has to understand the capacity of his partner and the factual consent of his partner to engage or consent to sexual relations. Then the next question, moving on from that, is there an argument to say that if P poses a risk of sexual harm, is that managed through the Mental Capacity Act, or is that managed through the criminal law? And then finally, perhaps if this issue actually is ventilated before the court, dun dun dun, dramatic pause, dramatic music. Should the test in respect of capacity to consent or engage in sex be person-specific rather than act-specific? So you've got all that to come next month. You will be able to watch, if you want, if you're a capacity geek, you will be able to watch the legal arguments live on Supreme Court TV. Yes, there is such a thing. Or you can watch them afterwards on YouTube. Next film, again, fantastic film, highly recommended. 3 Billboards Outside Ebbing, Missouri, or commonly known as 3 Billboards. I think it won about 1 million Oscars. It's about a woman whose daughter is murdered. And so essentially outside the small town in which she lives in Missouri, she pays for billboards which challenge the local authorities as to why they haven't found the person who killed her daughter. It's a fantastic film. One of the things that causes people problems in the Mental Capacity Act and using it is what happens when you have a situation where somebody would come along and harm P. So not where P themselves is going to harm someone, but where P themselves is at the risk of harm. And it's one of my cases there from last year called SF Injunctive Relief. SF was a care leaver who had been sexually abused as a child. As an adult, the abuse had continued. And essentially, SF was the subject of the attention of a relatively organised grooming gang. SF, because this grooming gang were constantly grooming her and she had capacity to consent to sexual relations, was all about how you deal with those people who would pose her threat or harm. And SF basically talks about how the court of protection has the power to impose injunctions on those people to stop them from approaching her and potentially harming her. So again, it really is an issue about the core starting issue in those scenarios is contact. So the relevant decision in respect of contact is generally, does P have capacity to have contact with others, or does P have capacity to have contact with a particular person, i.e. their abuser? Or there's a case called REOA, which I did earlier this year, which is about the concept of essentially having groups of people who pose a threat to P. So REOA was, again, a young man, a care leaver, who throughout his childhood had been subject to religious indoctrination from his family, who had been taken away from statutory services until he'd been the subject of care proceedings. He was taken into care, was then coming out of care, and the court had to deal with, well, what happens if his abusers return? Now, the interesting thing in EOA's case was that he actually understood, because of the indoctrination, ironically, he understood that some people in the general public wanted to pose him risk. And he understood that because he'd been given a sort of heightened sense of suspicion. So a sort of capacity decision saying that he had capacity, he lacked capacity to make decisions to contact with others didn't really fit. So what the Court of Protection did in that case was essentially break the capacity to make decisions to contact others down into categories. So essentially saying that in this case, EOA lacked capacity to make decisions as to his family members who were sort of signed up to this very small cult. Certain members of his brothers were sort of signed up, if you like, to the religious beliefs and the imposition. Others of his brothers identified that it was, something that didn't work and was, was harmful to them. So there had to be, again, a differentiation made between those brothers who recognised the harm in this sort of cult-like behaviour and those brothers who didn't. The other thing that we see far too often is that when there is a risk of harm posed to P, that the focus that's given by assessors is, well, there is a criminal conviction, there isn't a criminal conviction, and that effectively determines what happens. So, for example, we see cases where people say there are concerns about X's behaviour towards P, but X hasn't been convicted of everything, therefore it's not something we can take into account. That is fundamentally wrong. So the criminal court has a different standard of proof. The police do not arrest and investigate every crime. The CPS do not prosecute every crime. So there are cases out there where P has been the victim of crime, but there's been no arrest, there's been no investigation, there's been no prosecution. That doesn't mean that you can simply turn a blind eye to it. And instead, you have to think about what the evidence is and whether it's sufficient to pass the civil threshold, i.e. that it's more likely than not. And if it is more likely than not that something happened, then it can be included within the Section 4 best interest analysis. Likewise, over-reliance is placed on those agencies to mitigate risks that are identified. So often what we find is that social work professionals and in particular, quite often carers and care managers, domiciliary care agencies, identify a problem and then they go and tell people about it. And that's good safeguarding. You know, we make the report, we say, this is the issue, this is the concern. But the problem then is that often nothing is done, or there is a delay in something being done. And then you have the situation where P is at the risk of harm and public bodies know about it, in particular the local authority. So in those cases, it's at least arguable to say that there has to be some sort of impetus by the local authority to make the court aware about it, to try and protect P. The clue's in the name, court of protection. And then finally, a very strange argument that we see deployed sometimes, the argument that if nobody is receiving care, or the care isn't being commissioned by the local authority, that local authority has no safeguarding duty towards them. That is abjectly wrong. And I would encourage anybody who is being told that to challenge that type of decision. It is wrong. It will get you into a lot of trouble if you take that approach. How to improve your practice. If you are someone new to the world of mental capacity and court of protection, I would go and look at the OPG's safeguarding guidance. If you are intermediate, read the decision in EOA that I was talking about. And if you're an advanced person and a practitioner and you're thinking about how to get how to get one of those other agencies to do something, there is a Strasbourg decision called X, Y, and the Netherlands, which talks about how the police and how the criminal justice system has to protect people who are vulnerable due to being the victims of offending, even if they've got a learning disability, even if they've got a mental health problem, and so on and so forth.
Ian, I wonder if now's the time to take a break.
Yep, I am. I'm not far from the end. So when we come back, we can talk about young people and the Mental Capacity Act. But yeah, absolutely, now's a great time. So I can go and sort out my larynx and do my vocal exercises before we finish.
And there is some really key questions that have come through, in particular around the role of court protection of children in care of the local authority who are being exploited or abused.
Fabulous.
And the impact of traumatic stress and trauma on young people and the ability to make decisions themselves. So if we take a break now, if we take 10 minutes, just for everyone to have a stretch and a screen break and to refresh themselves, and if we come back at 11:40, we'll look forward to seeing everybody again then.
Super, thank you.
Thanks, Ian.